Judge Monosmith, can you hear us okay?
I can. Thank you.
Okay, all parties are here and we do have a record.
All right, thank you very much. First of all, I want to be sure our litigants are here. I don't see them at council table. Are William Bisson and William Delkey there, please?
Your Honor. William Delkey, sir.
All right. Why don't you have a seat up there at council table, if you would, please, sir. And same for Mr. Bisson. Just want to be sure each of you are in front of a microphone, if you would. All right, thank you. We have two matters before the court today. In the matter of William Bisson versus Gary Sini, that's cause 24-2-131-26, and the matter of William Delkey versus the Pend Oreille County Auditor Joe Sini and Brian Smiley. That's, I think I mentioned 24-2-132-26. It appears to the court that documents were filed by each litigant on August 19. In Mr. Delkey's case, that includes a notice of hearing for today and at this time, a complaint. I don't know exactly how it was denominated. It was a claim of candidate ineligibility in Pend Oreille County primary E of election of November. The clerk's stamp is over the top of it, but it appears that later that day, just after 4:30, there was a document with a cover sheet for an amendment or amended to original civil complaint. And I think it was intended to add the Pend Oreille County Auditor's Office. In cause 24-2-131-26, that is Mr. Bisson's matter. There was a civil complaint followed by a motion for order, followed by a notice for hearing for today at 1:30. So as I understand, those are the only documents in each of the two files. So I'm going to hear some brief argument today, but I perceive that there are some procedural flaws in each of these filings that we're going to need to talk about today. Let's see, Mr. Bisson, your filing was first in 131. Let me hear from you first, if I could, please.
Can you hear me, Your Honor?
I can. Please proceed.
Thank you. We had a PCO that I've been on for a while with the Republican Party. I am a member of the Republican Party. I pay dues. I work with the Republican Party. I filed the day before the closing, and I was on file at the time at 6:30 at night. The other gentleman, Mr. Sini, filed. What my argument for the case is that he is not a member of the Republican Party that I can find. There is no documentation showing that he's ever been a member of the Pend Oreille Republican Party. So this argument today is that he filed, his filing was not a proper filing for that position or candidate.
Has Mr. Sini been served with process, or has he been served with your complaint?
Yes, sir. He was served last night at 1806 or 1808. I don't have that correctly in front of me.
Is Mr. Sini present today?
Yes, sir, I am.
All right, thank you. Very well. Anything further then for your part, Mr. Bisson?
At the moment, no. Am I able to ask any questions of Mr. Sini, or are we just?
We're sticking with what's been written here. Mr. Delkey,
Yes, sir.
Your argument, please, sir.
we have been working with the state laws and the county officers since the primary filings, trying to get in front of court. We've run into all kinds of objections and delays, but essentially we are here today. I have copies of the candidates' signed declaration that they are members of the Republican Party, but they do not meet the condition for membership of the county Republican Party and therefore have filed their declarations under oath falsely. I was directed by the county auditor to take this case before the courts, as evidenced by an email response I have from them to provide to you. I'm not sure how we do that when you're not quite here.
By filing, sir, filing it in the court file is the way that you access or that the court accesses documents.
Okay. I am prepared to provide the court with proof that they are not members as defined by the PCO RCW laws of Washington State for county parties. And at this time, I respectfully ask this court to direct the county auditor to remove them from the certification of election based on perjury.
Right. Thank you.
Well, I have a secondary comment to that. I have not subpoenaed the now deemed elected PCOs in this procedural action, as I believe this can be handled under law by this court with the auditor's office. The auditor declared that they had no authority to change any of the applications, even though that we were contesting this under the RCWs. And so this is all happening, as you can imagine, off the election real fast, because under law, we have a 10-day window now that the election has been released by the auditor's office. So I did not subpoena the other two because our action primarily now focuses on the auditor's authority to allow these people to stay on and be declared elected.
All right. Thank you, sir. Mr. Cini, did you have any comments, sir?
The only thing I would like to bring up, sir, is on the paperwork that I've received that my name is spelled wrong. He had it under Joe Shawnee, SEANY, and my last name is SEANEY. And my legal name is Gary Joe Cini. And like he said, I was served yesterday, last night after 6 o'clock. And so I only had I had to take up a half day for this. And so I was not really too prepared to speak more on this. And I would need a continuance if I need to keep to proceed.
Right. Thank you. I began here by saying that I believe there are some procedural deficits that we need to address first and foremost. I begin by reference to 29A 68011. And even before I reference that, let me reference a couple other things. That is that our presiding judge, Judge Radzimski, asked me yesterday to step in here today to address the hearings that had been set for today. And I took some time to review these statutes. And I wanted to comment that these are rather opaque. They're not statutes that the courts typically work with, somewhat uncommon. We're accustomed as superior courts to dealing with recall matters, but not matters involving contesting elections under 29A 68. 29A 6811 is the legislature's directive about how these matters proceed. And it appears that these matters can be filed in either the Superior Court, the Court of Appeals, or the Supreme Court, because 29A 68.011 begins any justice of the Supreme Court, judge of the Court of Appeals, or judge of the Superior Court in the proper county shall by order require any person charged with error, wrongful act, or neglect to correct the error, desist from the wrongful act, or perform the duty and to do as the court orders, or to show cause forthwith why the error should not be corrected, the wrongful act desisted from, or the duty or order not performed, whenever it is made to appear to such justice or judge by affidavit of an elector that, and so on and so forth. So the first thing is the statute references an affidavit of the elector. Neither of the documents, whether denominated a civil complaint or a claim or a petition or otherwise, are in the form of an affidavit. And that really doesn't take too much, but it means a signature in the presence of a notary public, subscribed and sworn in the presence of a notary public. Neither of these two documents by Mr. Bisson or Mr. Dielke meet that criteria. Second, it says an affidavit, this is still proceeding under .011. An affidavit of an elector under this section, when relating to a general election, must be filed with the appropriate court no later than 3 days following the official certification of the primary election returns. I observe that these documents were filed on August 19th. My understanding is that the primary results were certified on August 20th. The statute, again, provides that must be filed the appropriate court no later than 3 days following the official certification of the primary election returns. So in my judgment, there are two significant procedural deficits to what have been filed here. One, not in the form of an affidavit, and two, filed prematurely, not filed after the certification of the election. So it seems to me, too, that there is 1 day remaining within which these errors can be corrected. So my thought here is, and I'd see also, let me say this, that the matter shall be heard and finally disposed of by the court not later than 5 days after the filing thereof. That means the filing of the appropriate affidavit. So, gentlemen, again, at least as I see it, these documents do not meet the criteria for the matter to properly be before the court. If you want to file pretty much the same thing tomorrow in the form of an affidavit and submit an order to show cause so that whomever you wish to show cause, certainly the holders of the offices who you claim to improperly hold the offices, that is Mr. Saney and let's see, Mr. Smiley, that's fine. You can submit those orders to show cause to Judge McCroskey. She'll fill in a date, which I would anticipate would be the next Thursday docket date, which is when we have a traveling Superior Court judge there in Pend Oreille County. And within that period of time, the statutes provide for the issuance of subpoenas. So if either of anybody wants to have a subpoena issued for example, the auditor, if anybody wants to have documents considered by the court up to and including perhaps the declaration of candidacy, I heard Mr. Dielke reference that. You can put them in the court file or file them in the court file. Anything you want the court to consider, you can either bring to that hearing and or file it in the court file. But my ruling today would be that these matters each would be dismissed without prejudice And without prejudice simply means that either party, both parties, have the right to renew their petition, their affidavit, as the statute provides, and submit an order to show cause. Because again, looking to 29A 68011, it says, as the court orders or to show cause forthwith why the error should not be corrected, the wrongful act desisted from, or the duty or order not performed. So again, I think we serve the holders of those offices, but to the extent the claim is that the auditor has improperly put those folks on the ballot or is about to improperly put those folks on the general election ballot, then probably that person needs to be brought in on show cause, to show cause why she shouldn't be directed to desist from doing so. So that's how I see it, gentlemen. This isn't a discussion today. It is my ruling. I intend to provide orders to the clerk this afternoon that dismiss each of these cases without prejudice, but under the terms that I've specified. And as I've indicated, I would encourage both parties to closely read 29A 68011, 020, 030, which addresses the contents of the affidavit for the error or omission, so that you might consider modifying your document, your affidavit, to be consistent with what the statute provides. And then, of course, 050 talks about witnesses and how the hearing is conducted. So, again, I suspect that there are many lawyers who would struggle with interpreting these statutes and interpreting precisely how the hearing is to be conducted. Wait, did you lose me here?
No, sir, we have it.
Okay, I can't see. I don't have visual anymore. But that's, again, some familiarity with the statutes, conforming your paperwork so it does meet the requirements of the statute, getting that done tomorrow and bringing an order to show cause into Judge McCroskey, who I presume will be there. She can fill out the dates, presumably for next Thursday's Superior Court docket, and getting the holders of the office served, and presumably serving the show cause order on the auditor. That's how I perceive these statutes are to work. And again, anybody wants to file a brief or a memorandum to assist the court in evaluating or assessing the meaning of these statutes and how they're to work together, by all means, please provide that to the court, because as I say, this is an area of the law that is not commonly dealt in by the court. So we'll call for questions. Mr. Bisson, any need for a clarification of the court's order, sir?
No, sir. Thank you very much for clarifying what you've talked to us about.
And Mr. Gilkey, same question, sir.
Essentially the same answer. The thing that makes it a little complicated is that one of the candidates was unchallenged and was certified at the end of the filing period. The other is a situation of a PCO that's doing a challenge. I'm not sure that we'll end up hearing both together, but I put them both together on this because I saw the need for the procedural decision. But as long as you're prepared to hear them or whoever gets it coming together as one case, I think it would be more efficient for the court's time and for all of us filing fees and all the things involved in that. But we're prepared to do that. We have all the documents ready to go for the affidavit. This is essentially what I expected as a procedural to get this on the right track. So I appreciate your foresight.
Sure, and you're quite welcome. And again, whether it's me or some other judge, they'll be dealing with this as best they can. It's as they say, an opaque area. No judge is going to know and shouldn't know, frankly, anything more than is in this file, anything more than is presented as evidence or what is testified to at the hearing. So please don't presume that the court's going to know who got elected to what, or what happened, without testimony or exhibits to that effect. So that'd certainly be. So you can keep that in mind. That's how a judge is supposed to be, is kind of a blank slate, and then decide the case based on the evidence that's in front of the court. So thank you, gentlemen. That'll be all today.
Perfect. Thank you.
Yeah.